Welcome to the Deep Dive. We're your shortcut to, well, really getting to grips with complex issues.
Yeah, cutting through the noise.
Exactly. And today we are plunging into a truly landmark South African legal battle, one that reshaped ideas about land rights and historical justice.
We're talking about the Alexkor Ltd v. Richtersveld Community case. It's from 2003, a really, really pivotal judgment from the South African Constitutional Court. And our mission, in this deep dive is to unpack it all for you. Make this pretty complex legal journey, engaging and accessible, whether you're just curious or maybe you're a law student needing a clear take on a major precedent.
Right. And the great thing is, we're going straight to the source. This whole deep dive is built from the Constitutional Court's own judgment.
Which means we get the court's thinking firsthand, unfiltered. It's the best way to understand why they decided what they did.
Okay, so let's set the scene. Who are the key players here?
Well, first, and most importantly, you have the Richtersveld community. This is a community with, centuries-long ties to this specific area.
Where exactly is that?
It's up in the northwestern corner of South Africa's Northern Cape Province. Very remote. And their claim wasn't for the whole massive region, but a specific part, a narrow strip along the west coast. They called it the subject land.
Got it. And on the other side?
You've got Alexkor Ltd. That's a state-owned public company. Their business, diamond mining. And crucially, they held the registered title, the formal deed, to that subject land.
And the government's involved too?
Yes, the South African government. They own Alexkor completely, so they were the second appellant. Interestingly, their initial position was just to, abide by the decision of the lower court.
Just accept whatever happened.
Sort of. But as we'll see, they changed their tune later and actually joined Alexkor's appeal at the very highest level. That became its own little side drama.
Okay, so what was the actual claim? What did the Richtersveld community want?
They wanted restitution. They were seeking the return of their rights in this subject land. And they brought this claim under a specific law, the Restitution of Land Rights Act. It's Act 22 of 1994.
And that act allows?
It allows communities who were dispossessed of rights in land after a specific date, June 19th, 1913, because of past racially discriminatory laws or practices. It allows them to claim restitution, to get those rights back.
That date, June 19, 1913, sounds really specific. Why that date?
It's hugely significant in South African history. That's the date the Natives Land Act came into force, a really foundational piece of segregationist legislation that dispossessed Black South Africans of land rights on a massive scale.
So the community had to prove two key things, essentially.
At least two big ones, yeah. First, that they had rights to the land. Second, that they lost those rights after June 19th, 1913. And third, crucially, that the loss was because of racial discrimination baked into laws or practices.
Okay, quite a high bar. How did this play out in the courts? Where did they start?
Their first stop was the Land Claims Court, the LCC. It's a specialist court set up specifically for these kinds of restitution claims.
And what did the LCC find?
Well, they found some things in the community's favor. They agreed, yes, this was a community under the Act. And yes, they had beneficially occupied the land continuously, even after 1913.
But there's always a but.
Exactly. The LCC concluded they failed to prove the dispossession was a result of discriminatory laws or practices. That was the fatal flaw in their case at that stage.
So claim dismissed.
Claim dismissed. A major setback for the community.
But they didn't stop there, obviously.
No, they appealed. The case went up to the Supreme Court of Appeal, the SCA.
And the SCA saw things differently.
Very differently. The SCA overturned the LCC's decision entirely. They granted relief to the Richtersveld community.
Wow. What were their key findings then?
The SCA dug deep into the history. They found the community had been in exclusive possession of the land, and importantly, this included the minerals under the land way back, even before the British annexed the territory in 1847.
Before 1847, that's going way back.
Absolutely. And the SCA said these rights were akin to those held under common law ownership. They recognized it as a customary law interest under the Restitution Act.
What does customary law interest actually mean in practice?
It means a right based on the community's own traditional laws and customs practiced over generations. It might not look like a modern property deed, written down in a registry office, but the law, specifically this act, says those kinds of rights still count. They're legally recognized.
Okay. And how did the SCA view the loss of those rights?
They looked at what happened in the 1920s, which was when diamonds were discovered on the land.
Ah, diamonds. That usually changes things.
It certainly did here. The SCA found that the state basically just ignored the community's existing rights, pushed them aside, dispossessed them, and eventually granted full ownership to Alexkor.
And was that discriminatory?
Yes. The SCA concluded that this dispossession did amount to racially discriminatory practices, a complete reversal of the LCC's finding on that crucial point.
So victory at the SCA. But Alexkor and the government appealed again.
They did. They took it to the highest court in South Africa, the Constitutional Court. They needed special leave to appeal, which the court granted.
And this is where that government side story comes in. The abiding the decision bit.
Exactly. So the government had initially told the lower courts, whatever you decide, we'll accept it. But then, after the SCA ruled against Alexkor and effectively against the state's interests,
They changed their minds.
they sought leave to join Alexkor's appeal right at the end. The Constitutional Court wasn't impressed with the delay. They actually heard a separate application just to let the government join.
And they made them pay for it.
They did. A special costs order against the government on an attorney-client scale, which is punitive for the unacceptable delay. It really shows how significant the court viewed this case, and perhaps their displeasure at the government's tactics.
Okay, so everyone's at the Constitutional Court. What were the big legal questions they had to tackle?
Well, first, a fundamental one about the court's own power, its jurisdiction. Alexkor and the government questioned whether the CC could even rule on all the issues, especially the really historical stuff about rights before 1847.
Like, is this ancient history really a constitutional matter for the highest court?
Precisely. But the CC took quite a broad view. They reasoned that the Restitution Act itself is giving effect to a constitutional right, Section 25(7) of the Constitution guarantees restitution.
Right.
Therefore, interpreting and applying that act is a constitutional matter. And if you need to understand the history, even pre-colonial history, to properly apply the act.
Then that history becomes relevant to the constitutional matter.
Exactly. The CC said, even these anterior matters, like whether rights existed before colonization, are issues connected with decisions on constitutional matters. So yes, they fell squarely within the CC's jurisdiction. It was an expansive, purposeful approach.
That makes sense. If you're trying to fix historical injustice, you kind of have to look at the history.
You have to be able to. Otherwise, the constitutional promise of restitution could be undermined.
Okay, jurisdiction sorted. What about the time issue? You mentioned the Constitution isn't usually retroactive.
Right. The CC confirmed its general rule. The Constitution doesn't go back in time to invalidate acts that were legal then.
But the Restitution Act specifically points to that 1913 date.
Correct. June 19th, 1913. That date is explicit in the Constitution and the Act. The dispossession itself must have happened after that date for a claim to succeed under the Act.
So you can't claim for something that happened in, say, 1880.
Not under the specific act, no. But, and this is a key nuance the CC pointed out, the court can still look at discriminatory laws or practices from before 1913.
Why?
If those earlier practices throw light on the nature of a dispossession that took place thereafter, or if they show a kind of continuous process of discrimination that culminated in a loss after 1913.
I see. So the pre-1913 context matters for understanding the post-1913 event.
Precisely. However, the court was also clear. When judging the legal effect of something that happened before 1913, like the 1847 annexation, you have to use the law that was in force at that time. You can't apply today's standards retrospectively to judge the legality of the annexation itself.
A delicate balancing act.
Very much so, acknowledging history without improperly rewriting it through a modern legal lens.
Okay, this leads us right into the heart of it. What rights did the Richtersveld community actually have before all this? Before 1847.
This was a massive point of contention. Alexkor's argument was basically whatever rights they might have had, they were wiped out by British annexation in 1847. Full stop.
But the Constitutional Court disagreed.
Strongly disagreed. And this is where the judgment gets really groundbreaking, particularly for how South African law views Indigenous law.
How so?
The CC made a powerful statement. It said Indigenous law or customary law must be seen as an integral part of our law. Not viewed, as it often was in the past, through the prism of common law, like some lesser exotic system.
So putting it on equal footing.
Essentially, yes. Recognizing it as a living, valid legal system under the Constitution itself. This wasn't just about history. It was about the present status of Indigenous law.
And based on that Indigenous law, what did the evidence show?
The court looked at the findings from the lower courts, which were extensive. It showed communal ownership under the traditional Nama law of the Richtersveld people.
What did that ownership involve?
Exclusive occupation and use grazing, water sources, hunting. Critically, there was undisputed evidence they mined copper there long before Europeans arrived.
And minerals were key here.
Absolutely. The evidence also showed the community granting mineral leases to outsiders later on, between 1856 and 1910. Outsiders needed their permission, sometimes paid for access, all pointing towards, well, ownership.
So the CC's conclusion was?
That the Richtersveld community held a right of communal ownership under their indigenous law before annexation. And crucially, this ownership right explicitly included the minerals and precious stones under the ground.
Okay, that's huge. They owned the land of the diamonds, according to their own law, before 1847.
That was the finding.
But then annexation happened. Alexkor argued that Brecci wiped the slate clean. How did the CC counter that?
They tackled it head on. They said, look, annexation is an act of sovereignty. It means the British Crown takes over governing power, but it does not automatically extinguish existing private property rights.
So taking over the country doesn't mean taking everyone's houses.
Kind of, yeah. The court stated there's an expectation, a principle, that the new sovereign power will respect existing property rights unless they are explicitly terminated.
Explicitly, like passing a specific law saying these rights no longer exist.
Exactly. Through clear legislative acts or specific state actions, the CC looked at the Annexation Proclamation of 1847 and other laws afterwards. They found no such express act extinguishing the Richtersveld community's rights.
So the right survives annexation.
That was the CC's conclusion. The community's indigenous law ownership rights, including minerals, continued to exist legally after 1847.
Wow. Okay, so if the rights survived annexation, they must have been lost sometime later. When and how did that happen, especially after the key date of 1913?
Right, that's the next big question. Alexkor tried arguing some earlier laws, like the Crown Lands Acts from the late 1800s, did the trick.
But the CC rejected that.
Yes. The CC found those acts didn't actually extinguish ownership. In fact, they contained provisions that could have been used to recognize the rights of people like the Richtersveld community who were occupying land without formal title. But the governor never actually made such a decision for Richtersveld.
So not those laws. What was the real trigger for the dispossession after 1913?
The game changer, again, was diamonds, their discovery from 1926 onwards, and specifically a law passed in response, the Precious Stones Act of 1927.
This act sounds pivotal. What did it do?
Its critical effect was that it simply failed to recognize unregistered indigenous law ownership. The system it set up only really acknowledged land held under registered title deeds.
The kind of deeds the Richtersveld community wouldn't have had under their customary system.
Exactly. So any land not formally registered, including the Richtersveld subject land, was treated by this act as unalienated crown land, basically vacant state land.
So their centuries of occupation and ownership under their own law just became invisible to this new statute.
Precisely. It was as if their rights didn't exist in the eyes of this law. The act went further. It effectively made the community's continued occupation and use of the land, even getting water, unlawful. Criminal, in fact, without specific permissions they couldn't get.
That's devastating. Turn them into trespassers on their own ancestral land.
Effectively, yes. Then, starting in 1928, the state established its own alluvial diamond diggings on the land, fenced the community out, physically excluded them, and eventually transferred the full registered ownership to Alexkor.
So the CC concluded this was the dispossession.
Yes. The Precious Stones Act of 1927 and the state actions that followed under it effectively stripped the Richtersveld community of all their ownership rights, including the minerals, after June 19, 1913. And this process was complete by 1993 when the final bits of land were formally transferred.
Which brings us to the final hurdle. Was this dispossession based on race? Was it discriminatory?
Yeah.
The LCC initially said no, using that narrow spatial apartheid test.
Right. The LCC had followed an earlier case, Slamdian, which set a high bar requiring proof of explicit racial zoning intentions. Under that test, the Precious Stones Act didn't look discriminatory on its face.
But the Constitutional Court rejected that narrow test.
Absolutely. They called the Slamdian test unduly restrictive. The CC looked deeper.
What was their reasoning?
Their reasoning was subtle but powerful. They said the Precious Stones Act created a system that differentiated between types of land ownership. It recognized, respected, and protected registered ownership the way most white people held land.
Oh.
But it completely failed to recognize or protect Indigenous law ownership the way most Black communities, like the Richtersveld, held land.
So even if the law didn't say Black people lose their rights, the effect was racially biased because of how land was held by different groups.
Exactly. The court focused on the impact. It said this differential treatment, this failure to accommodate Indigenous law rights while protecting registered rights, had an inevitable negative impact along racial lines.
So discrimination isn't just about intent. It can be about discriminatory effect.
Precisely. The court said the inevitable impact of how the act was structured was racial discrimination against the Richtersveld community. Even if the lawmakers in 1927 weren't thinking explicitly in terms of racial segregation with this specific act, the way it operated within the broader discriminatory context of the time made its impact racially discriminatory.
A much broader understanding of discrimination.
A hugely important development. It meant laws that appeared neutral on the surface could still be found discriminatory based on their real-world impact on different racial groups, especially given the historical context.
So the final conclusion from the Constitutional Court was?
They upheld the Richtersveld community's claim. They confirmed the SEA's finding but tweaked the order slightly. They declared the community was entitled to restitution of the right to ownership of the subject land, including its minerals and precious stones. Not just rights akin to ownership, but full ownership recognized under current law. A stronger affirmation.
And the costs.
Alexkor and the government had to pay the community's legal costs. And remember that special punitive costs order against the government for their late attempt to join the appeal.
What a journey. This case feels incredibly significant.
It really is. It's a landmark for land restitution in South Africa, obviously. But it's also massive for the recognition and integration of Indigenous law into the mainstream legal system.
And for anyone studying law, it's a masterclass in constitutional interpretation, right?
Definitely. How courts grapple with history, how legal definitions like dispossession and racial discrimination can evolve and be broadened to achieve substantive justice, not just formal equality.
And just for everyone listening, it's quite a story, isn't it? A community sticking to their guns, using the legal system, relying on their own history.
Yeah, achieving this profound victory against, let's face it, very powerful state and corporate entities. It reshapes how we think about property, about who belongs, about equity.
It really does. And it leaves you thinking. This deep dive showed how laws and systems, maybe looking neutral on paper, especially historical ones, can have these deeply unfair, discriminatory impacts. It makes you wonder, doesn't it? What other historical policies or practices, maybe things we take for granted even in our own context today, might actually reveal hidden biases if we looked closer, things that maybe need a reevaluation.
That's a very provocative thought to end on. How much of our present is still shaped by subtly discriminatory frameworks from the past?
Something to think about. Until next time on The Deep Dive, keep digging deeper.